guys haven't gotten any drops? Just set up the Zoom. We should get started. All right, everyone, we're gonna get started now. Who have I not met in person yet? We're gonna get started. Who have I not met in person yet? I'm Jay. Matt. Kelly. Samir. Samir. Gotcha. So, gotcha. Got the two. Kyle. What's up? So my name is Charles TJ Esposito, and I'm the managing attorney for closing attorney. If you are in the Slack group and you are in the legal channel, you see me responding back to all the questions and stuff too if you're on. So if you guys have any questions, you can always put it in there. Every so often, Slack, like the messages come through for me, so if I don't respond, you can always shoot me a text too. But for the most part, I should checking that. And then if I'm doing something like this and I'm unavailable, I have the way message up on my text, my email. So if you get something like that, and you wait for me to be done and get back to you, or Nick and Trisha, the other attorney, this too, go to the call and ask you a question if you have one, or have a contract if you have one. Okay. We're gonna go over the as-is contract today, changes to the as-is contract. So when we do a normal contract review, I normally go through every section that is pertinent in the contract and talk about things that we deal with most on a day-to-day basis. But now we're gonna go through the changes that they just come out with for November. So and everybody, yeah. Yeah, if you're take charge, please take it.
Your volume is not on.
Yeah.
Okay.
The contract is, I'm going to be sharing my screen up here.
That's me. I said I can't hear you. We can't hear you.
So I'm sharing it up here, but we also email. And, feel free to ask any questions, doesn't have to be about just the changes. So
Okay, hi everybody that's at home. We're gonna get started now too. Okay, this is the as-is contract that has been released this month in November of 2021. And you will not find this version of the contract online. I emailed it to Courtney and Bridget so that you guys have it. These highlights are my own highlights. I went through the contract and highlighted the changes. The contract that's on the Florida Realtors website, that is the draft, does not have any changes on it. And the contract that has the red lines on it is like impossible to read. So the first section that has changes on it is the personal property section. They've added in thermostats, doorbells, TV wall mounts, and television mounting hardware. And there is a little bit of an echo, so I don't know who's getting picked up. I don't know. Is it?
So, but I will make sure.
Can you mute? I don't think I have the ability to mute everybody. Okay, that seemed to work. Okay, so the personal property section, thermostats, doorbells, TV wall mounts. If you guys are listing a property and you notice that there are Nest thermostats, Ring doorbells, things like that, your seller may have put over $1,000 into smart technology that's in that home. And you are going to want to make sure you go over with them whether or not they are going to be taking that or leaving that. Because if they think that they're taking it, you need to modify this contract now to make sure that it doesn't say that they have to leave it. Because this contract is now saying that they have to leave these things for the new buyer. And if you're on the buyer side and you're viewing a property and you're looking at this house that has all these brand new upgrades and smart technology things like doorbells and thermostats, you need to get on the same page with the listing agent and make sure that if you've entered in contract saying that the seller is going to leave these things, that they actually leave it. And as with everything in the personal property section, these are things that you really won't find out about until the walkthrough. So you enter into contract, you do your inspection, everything's still in the property, but then when you go back for the walkthrough, things will be missing. And that's when disputes happen. So you don't want to set yourself up to have a dispute the day of or the day before closing because of something like a thermostat or a doorbell. And even though they're only a couple $100 individually, a seller the day before closing is not going to want to give a credit to a buyer. And the buyer is going to want that credit, or they're going to want the doorbell to be put there because that's what they were buying. And then it ends up coming out of your guy's pocket, whether you're the listing agent or the buyer's agent, because you're like, we need to close, I don't care. But that's a couple $100 out of your pocket. That's what always ends up happening, and you don't want that to happen. So before you enter into contract, if you're the listing agent, figure out with your seller what is staying, what is going. And this goes for everything in the personal property section, not just the new stuff, okay? If you have a chandelier in the property and it's a big, beautiful chandelier, you can't just assume that that's going to stay with the property. You have to ask the seller and figure that out. Okay, same thing if you're on the buyer side. If you see all these different things in there and you can't just assume that your buyer's going to get it, because your buyer is going to assume that they're going to get it. And the seller might be assuming that they're taking whatever is very expensive in the house with them. TV wall mounts. I believe they've added this into this section because people are taking the TVs off the wall and the wall mounts, and they're leaving giant holes in the wall and they aren't patching them up properly. So the seller can take the TV with them, but not the wall mount. If you are entering into this contract and not making any modifications to it. So again, you have to be on the same page with the seller, and you have to make sure that you know what they're going to take, what they expect to take, and what they expect to leave. When you enter into a contract from the buyer side, I always recommend entering into the contract first and then having this conversation with the listing agent, because all of this stuff is supposed to go to the buyer. So if you enter into contract, you do your inspection, then you can check in during the inspection period with the seller, the listing agent. Hey, just want to make sure, okay, all these thermostats, all these doorbells, all the TV mounting hardware, that's all staying here per the contract. And if the listing agent is like, oh, I didn't talk to my seller about that, well, you are putting yourself in position during the inspection period to take care of that problem, asking for credits. Yeah, seller, you can keep the 5 doorbells and thermostats and everything, but you're going to give a credit of $1,000 to the buyer. Now the buyer can go out and buy whatever the heck they want. So that's putting you in a good position with your buyer to negotiate for what they should get based on the contract that's already signed. Okay, so you have to figure out, based on whether you're on the listing side or based on whether you're on the buyer side, what type of tactic you're going to use and what you should be looking out for. Question.
My question to you, once we get the report, if I'm the buyer's agent, I get the report and there are things on the report I've already need to address. Do I just add the additional stuff on there, or just have a conversation with them prior to me even submitting the what?
So,
or an addendum or anything of that sort?
Yeah, when you're submitting an offer?
No.
Or
we're in the inspection
period. In the inspection
period.
period.
The inspection, I get the inspection report back.
Mm-hmm.
Then I have a conversation. Should I have that conversation prior to me even sending what I want back from the inspection report, or should I just make that one big?
When you have the conversation with the listing agent about the inspection report, I would negotiate the things that are in the inspection first, And then I would confirm with them about all the personal property stuff afterwards, because then you can more easily separate it. If you start talking about the personal property stuff while you're asking for credits for repairs or something like that, they're going to try to lump all that in together, you know, and you'll be able to separate it more easily. Now, on the MLS, if you are a listing agent or you are buyer's agent and you are either writing on the MLS what the seller is keeping with them, or you're looking at an MLS offer and you're seeing that the seller is going to take certain items with them. Okay. From the buyer side, don't submit a contract that's just blank. You know, put the actual items on the contract on your offer that the MLS is saying are excluded, because you don't want to set your buyer up for a dispute going into the contract, especially in the seller's market where sellers are trying to get out of contract and using every excuse to get better offers and things like that. You don't want to enter your client into a dispute from day one, and you don't know whether that listing agent is really paying attention to your offer or not, or just looking at the bottom line. Yeah, it might be the highest offer, but then all the items that were being excluded on the MLS are not included in it, and then all of a sudden you guys are arguing about things from day one. Okay. And then from the listing side, if you're putting things in the MLS that are excluded, you have to make sure that they're put on the contract afterwards, because the MLS is not a contract between the buyer and the seller. This contract will supersede whatever's written in the MLS. Okay. Keys and storm protection items. They added mailbox keys here, but they also have keys in section 6. So any keys that the seller has, they're supposed to be turning over to the buyer anyway. If it's part of an association, or you have to pay for mailbox keys or like pool keys or anything like that, I typically, my rule of thumb is that the seller is supposed to be responsible for those items anyway, because they either got keys from an association for a common area or for mailboxes or something like that, and they lost them, and they're supposed to replace them. Because if there's a fee for it, then how is the buyer supposed to get that without paying something additional? So again, everything is negotiable though. From the listing side, you want to check with your seller before you enter into contract. What keys do you have? What keys are you missing? So that you can actually negotiate with the buyer about the keys, so that you're not dealing with this on walkthrough where all of a sudden keys that the buyer was expecting to get are not there, and then they're asking for a credit. Okay. With the storm protection items and hardware, most commonly we deal with keys for those. So if we have storm shutters that the seller doesn't have a key for, the storm shutters are not really much use if you can't lock them. And those keys typically cost a lot more to replace than regular keys, because they have special locking mechanisms on there. So that's something to definitely be on the lookout for when you are on the listing side, because if your seller doesn't have these things, that's fine, but put it in the contract. Make sure that the buyer knows about it, so that you're not arguing about this stuff prior to closing. Okay. They notably did not add in washer and dryer, so you still have to keep adding in washer and dryer to the personal property section as well. Okay. If you are going to change this section, I would recommend crossing off items here and then also writing them in the excluded section. So if the seller's taking the thermostat, cross it off in section 1D and add that it's excluded in 1E. If you have a property that's very high end and there's a lot of high end appliances in there, I always recommend just creating a separate addendum stating which appliances are being sold with the property, because you don't want your seller taking out a $10,000 refrigerator to bring to their new home and then replacing it with a cheaper refrigerator. Same thing if there's a refrigerator in the garage, stuff like that. That's all the same. You're going to deal with that exactly the same as you did under the old contract, but the new contract now has these new items too. Any questions on the personal property section before we move on? Okay.
I have one question.
Yeah, question.
The crossing out, I've never seen anybody ever cross it out. Is that
Yeah.
standard? Like what happens if you don't cross it out, but you still put it in the next line?
Yeah, you don't have to cross something out that's up there if you're excluding it. But to me, it's kind of confusing, because then one section says that
It is
something's
included,
included, and then the next section says it's not included.
but the most important
So-
is to move it down to the.
Yeah.
excluded line.
Yeah, you absolutely have to put it on the excluded line if it's
Yeah.
going to be excluded, but I would recommend crossing it off too, because it's there now. Okay, the closing date section, they added in when all funds are required for closing are received by closing agent and collected pursuant to standard S. Okay, so this is saying we can't close unless the closing agent has the funds. This is exactly the same as we've always operated, but they've added it in to clarify. Okay, so for instance, I've had buyers that have said to our office, we'll do a dry closing, and they haven't sent us any money. That's not what a dry closing is. A dry closing is when we have all of the money and we close the transaction, but we just can't fund it because it's like 8 o'clock at night or something like that. Okay, so we cannot close a transaction unless our office, if we're the closing agent, has all of the funds. So the lender may send us the funds the day of or the day before, and the buyer sends their funds to us. Sometimes we're waiting on a wire to show up in our account, which is why we're all sitting around waiting to close. All the paperwork is signed, we have everything that we need, but there's no money in our account. We can't just say, oh, we'll do a dry closing and hand the keys off to the buyer because we have no money. So this is making it absolutely clear that you cannot do that, okay? The closing date is now on the second page. I've already had multiple contracts that I've had to review that has the closing date blank on here because people have missed this because it just got moved to the second page. So please don't miss this. You need to have a closing date on the contract, otherwise it's not a valid contract. You can't have a contract that doesn't have a closing date. It's one of the key terms, okay? The next section is section 5, the TRID clause section or CFPB requirements. So you may have dealt with this section if you have a lender on the closing date has said, oh, we can't close today. We need an extension for 3 days because we didn't disclose the CD to the buyer yet. If you've dealt with that, this section is what governs that, okay? And we normally call it the TRID clause. They've added in here, loan approval has been obtained and lender's underwriting is complete. So what does that mean? If the lender is telling you we haven't disclosed the CD and we need an extra 3 days to be able to close, okay, this section is now saying they can only take advantage of that if loan approval has been obtained and their underwriting is complete, which generally I say is just clear to close. The buyer has to be clear to close in order to take advantage of this extension clause, okay? From the seller side, every time we represent a seller and a buyer's lender is saying that they need this extension, we always ask for, do you have clear to close? Because if they don't have clear to close, they may just be trying to use the CD disclosure as a way to get a couple extra days to clear conditions, okay? It's now very, very clear here that they can't do that, okay? So if you are working with a lender that you trust, who's a good lender, which most of you guys are, they should be disclosing the CD well before the closing date. There is no rule that they have to wait for clear to close to disclose a CD. If there are lenders though that wait until they have clear to close to issue a CD, which is kind of crazy because a lot of lenders don't get clear to close until like the day of closing. So you have to be wary of that. If you're on the listing side, you should be asking your the lender for the buyer, you know, did you disclose the CD so that we don't deal with this problem? I've had especially buyers that are asking for an extension to the closing date or something like that. Before we even talk about extending the closing date, I always ask the lender, did you disclose the CD? Because I don't want to extend the closing date and then find out on the new closing date that they didn't disclose the CD and now they're asking for another 3 days. Okay. So that's what this section is all about. They also changed the time period from 10 to 7 days, which I didn't actually highlight. We've never dealt with an extension that extended the closing date more than like 4 or 5 days because of a holiday maybe. So I guess the Florida Bar and Florida Realtors haven't either, so they shortened that time period to 7 days. CFPB requirements are set by Congress and the CFPB board. So these requirements for lenders are subject to change. So if Congress ends up coming up with a new requirement for lenders, it's very possible that there could be new requirements that we have to deal with that would extend the closing date beyond the 3 days. But for right now, pretty much all we deal with is the closing disclosure, and the other requirements that would extend the closing date, they usually happen so early on in a transaction that they never affect the closing date. But it is possible for other ones to affect it. We're going to come back to this section when we start talking about the financing section too. So we'll talk a little bit more about this later. Occupancy and possession. Section 6A deals with when the property is going to be handed over to the buyer without anybody occupying it. Okay, so no seller and no tenants in there. They've added a reference to Rider T, which is the pre-closing occupancy by the buyer rider. I do not recommend ever doing a pre-closing occupancy agreement. We don't want to let the buyer into the property before we've closed, okay? Because if the buyer doesn't close, what is the seller going to do? They're going to have to evict that buyer, and it could take a long time to get them out. And then, yeah, absolutely. And then you guys as agents, whether you're on the listing side or you're the buyer's agent, if you're allowing that person to go in the property, you haven't gotten paid and you've given occupancy to that buyer. That's not a great position to be in either, you know? So, and you don't necessarily know your buyer if you are a buyer's agent. That could just be a lead that you got off the internet and you don't really know that person. So you don't want to do a pre-closing occupancy unless it's absolutely necessary. And if you are thinking about doing one, or the seller is saying, well, we're willing to do this, then that's something you guys should discuss with me and try to make sure that we're protecting everybody as best we can. But it's an enormous risk for the seller and for the transaction. I've had a buyer in $1 million property occupy it ahead of time because they got buddy with the seller, and then they were in there for 6 months without closing, and then the seller had to evict them, and they caused like $50,000 or $60,000 worth of damage to the property. They enrolled their kids in school. It was absolutely nuts, and they never ever paid anything, not a dime. You know, they committed bank fraud. It was really kind of crazy. And the seller in that case, they ended up not listening to our recommendation, which was, you know, not to let the buyer into the property. They just let him do it. So it was crazy. So that's one horror story from pre-occupancies. Section 6B, if it's checked off, is when someone is going to be occupying the property after closing, okay? And either the buyer is assuming a tenant or the seller is occupying the property post-closing. They've added in here a line referring to seasonal and short-term vacation rentals. So if you're dealing with seasonal rentals or like Airbnbs, this would apply to that. And they've also created an addendum for seasonal and short-term rentals. So if you're going to have a seasonal rental property or an Airbnb type property, there's an addendum for that now. And we're going to go over that a little bit later. They've also added in the line that says tenant estoppel letters shall not be required on seasonal or short-term vacation rentals. So the normal way that this section works when there is a tenant is that the seller has to give the lease to the buyer reviews the lease, and then the tenant has to give a tenant estoppel to the buyer. Okay, and that's just a form that the tenant fills out confirming the security deposit, the rental amount, and any other terms of the lease. And if you think about it, you as the buyer, if you're representing the buyer, you don't want to just take the seller's word for it that the lease that they have is the correct and final version of the lease. It could have been amended. There could have been an additional security deposit. Sometimes there are pet deposits that are not included on the original lease. And if you just go by what the seller is saying and we close and we do the prorations based on what the original lease says, your buyer can be on the hook with the tenant for additional monies that nobody contemplated. So that's why you need to get a tenant estoppel. And in standard D, which is in the back of the contract, it actually outlines the timelines for tenant estoppels and when they're supposed to be due and all of those things. And if you need a tenant estoppel, if you're doing a transaction that has a tenant in it, our office has blank tenant estoppel forms that we can give to a tenant.
So the tenant estoppel form is something that us as a buyer's agent needs to send to the listing agent to have the tenant fill out. It's not something that the sellers provide, right? I mean,
The seller is technically supposed to provide it, but 9 times out of 10, the listing agent will be like, I don't know what that form is, or we don't have that. And you as a buyer's agent, you need to protect the buyer anyway. So you need to make sure that you're getting that document, you know. The other thing too is you want to make sure that the tenant's actually the one that's filling it out. I've had landlords fill out tenant estoppels and just hand it back, and it's like asking them for the lease again. You need to make sure that the tenant is aware of what's going on. And our tenant estoppel form, we added a section onto it for whether or not there have been any damages to the property or anything like that. Because if you have a seller landlord that's trying to conceal something like a leak or anything wrong with the property, if the tenant is looking at that on a tenant estoppel form, they have an opportunity to disclose that to everybody, which is another reason why a landlord may prevent a tenant from filling out an estoppel. But if the standard D in the back of the contract says that if the landlord doesn't provide the tenant estoppel, then the buyer has the opportunity to actually speak with the tenant and talk to them about the lease too. So it's one or the other. If there's no tenant estoppel, then the buyer should be put in touch with the tenant to start talking to them about their lease term and all of the sections of the lease that would be pertinent for the buyer.
So what
Okay.
does that look like as far as a buyer reaching out to the actual tenant? Basically knocking on the door?
It could be anything. It could be a phone call, they have to be put in touch with the tenant. It's and if the seller doesn't allow them to do that, then the buyer could back out of the contract. That's what it says in standard D. Okay.
CJ, it's Anastasia. I just had a question. So you mentioned for the tenant estoppel that sometimes you've witnessed landlords filling that out. So how do you know if the tenant's filling it out? Is it going to be notarized? I mean, how do they validate that it's the actual tenant filling out that tenant estoppel?
Well, I mean, a lot of times they're signed electronically. If they're signing it as the tenant, then they're committing fraud, but for the most part, you as the buyer's agent, if you are, if you're dealing with a property where there's a tenant, I would be in communication with that tenant, either over the phone or in person. If you're not, then that kind of is throwing up, red flags. Like, how is the buyer as the new landlord never talking to the tenant, or the buyer's agent? It just kind of, it's a little bit shady if the landlord's not allowing you to talk to the tenant,
Okay, got it. Thank you.
Mm-hmm. Okay, assignability, section 7. They've added in, if no box is checked, then the buyer may not assign the contract. So the default here, if no boxes are checked off, is that the contract will not be assignable. Okay. The section 8 for financing, we're going to spend the most time on this section, okay? Because these are where the most important changes are, and especially on the buyer side, you're going to be required to do things that you weren't required to do under the previous contract. Okay, so everybody, if you're falling asleep, time to perk up and take your energy drinks. Yeah, 7th inning stretch. We'll do the section 7 stretch of the contract. Okay, section 8 for financing. 8A, this is a cash transaction with no financing contingency. This is exactly the same as the previous contract, except they just removed all the fluff. The previous contract talked about lender financing and Cfpb requirements and things like that, and basically just said that none of that stuff applies. So the Florida Realtors explanation for this is, well, since none of that stuff applied, we just deleted it anyway. So important note on cash transactions. If this box is checked, it doesn't mean that the buyer can't get financing. They can get financing. They can get the money from anywhere. It just means that they don't have a financing contingency. Okay, so they don't have a loan approval period. And if they are getting a loan on a cash transaction, they can't back out of the contract because they didn't get the loan. They have to close, okay? So their deposit will be in jeopardy. When it's a cash transaction, typically the buyer's only contingency is their inspection period. Section 8B. Okay, this contract is contingent upon within, if left blank, then 30 days after the effective date, loan, and that is the loan approval period. That's exactly the same. They've added in part 1 and part 2 now. Part 1 is exactly the same as it was before. The buyer's going to obtain a loan approval for conventional FHA or VA loan, a percentage, prevailing rate, and then if left blank, a term of 30 years. That's exactly the same, the financing section. Part 2 is the appraisal. They've now added the appraisal to the loan approval period. So the buyer, if their loan is conditioned on the property appraising, they have to get the appraisal done during the loan approval period. If they don't, then they cannot get loan approval per the terms of this contract. Okay, so the previous contract only had the financing section, and then it said if the loan approval was conditioned on the property appraising and they lost loan approval because of an appraisal, then they can back out of the contract. That's what the previous contract said. This one doesn't have that option to back out because of an appraisal. The buyer has to get their appraisal done during the loan approval period. And if they don't, then they can't get loan approval. Okay, so it's a huge, important distinction and change that they've made to this contract. And in this market where it's taking forever to get appraisals, you're going to see a couple of different things. You're either going to see longer loan approval periods, 21 to 30 days, and then hopefully the appraisal comes in during that time. Or you might still see shorter loan approval periods, but then accompanied by appraisal contingencies. And we're already seeing a lot of appraisal contingencies anyway, because properties are selling above list price, and sometimes well above list price. So we are used to seeing a lot of different appraisal language. And if you need appraisal language, I do have specific appraisal language for a lot of different situations. Let's say the seller is going to reduce the purchase price, or the buyer and seller agree that they're just going to renegotiate if the appraised value comes in so low. So we do have language for that. We're going to talk about later on in this section what the implications of not having the appraisal done during the loan approval period are as well. All right. Yeah, questions.
So if, as, two part, so as a seller's agent, if I get a contract and this is a contract that comes to me, would it behoove me to like reach out to that buyer and be like, buyer's agent, be like, can I speak to your lender, or are you aware of this part of this contract? Is your lender aware of this? Because they have a certain time frame to be able to do this.
Yeah, absolutely. So from the listing side, anytime you're getting an offer with financing, first of all, if it's accompanied by a pre-approval letter, pre-approval letters don't really mean anything. So you normally want to ask for a DU, which is desktop underwriting. And if you can get that, great. Roni's question is, should we be reaching out to the lenders to make sure that they understand the appraisal language and that they have to get it done during the loan approval period? Yeah, absolutely. Ask that lender if they're ordering rushes on their appraisal. If it's a lender that is a big institutional lender, they may have no idea what this contract says. So this is also a seller's market too. If you have a listing, you might be getting a ton of offers on the property. One of the things that would make an offer more attractive is if the buyer's lender is somebody that you know. So I also have listing agents who are telling buyer's agents, well, listen, there's a million offers on this property. Who's your lender? Okay, I don't know your lender. Either I want to talk to them and get comfortable with them. And if I'm not comfortable with them, the way to make your offer better is to use the seller's lender or a lender that I know, because then that kind of lifts the veil between the buyer and the seller. When you are the seller, you don't have any control over the buyer's lender and whether or not they can they can close. In Palm Beach County, you could choose the closing agent. So at least if my office is doing the closing and you have the seller, we at least have a line of communication with the lender and we can find out more information, you know, but that's still no control over the actual transaction. If you have the buyer and the buyer's choosing an institutional lender like a Bank of America or something like that, and you don't know the person they're working with, you have no control over whether or not that lender is going to tell you really the truth, or they're just going to kind of, you know, BS their way through the transaction, because that happens a lot. So this contract with having the appraisal in the loan approval period, it gives you as a buyer's agent more ammunition to say to your buyer, listen, if your lender doesn't really understand this contract, that's all the more reason to go with somebody that I actually trust. You can't make your buyer choose the lender that you work with, you know, but you could certainly say, you really should talk to my lender before you go with your Bank of America people who you've dealt with for the last 30 years, because those people really don't actually care. You know, there are some, you know, lenders that are at Bank of America that do a lot of business and work, you know, like, you know, maybe smaller lenders do, but they're few and far in between, you know? So you really have to make sure that you're on the same page with the lender if you're on the buyer side. And from the seller side, you should be trying to get as much information out of the lender as you possibly can, because you have to vet that offer that's coming in. And in this market, you're getting a million offers, you know? Question.
I'm representing the buyer in a situation where the seller wants a 14-day loan commitment, and we're not sure if the lender can get an appraisal in 14 days, then we should add an appraisal contingency writer.
Absolutely. Yeah, and we're going to go over how to work that in a couple of minutes too. So the question was, if the seller's not accepting a longer loan approval period and they want like a 14-day loan approval, should we include an appraisal contingency? Yes, absolutely. But then you're going to have a couple of added steps now too, because of what else is written in this section. And we're going to get to that in a couple minutes and tie everything together. Okay. So we're going to talk about this again. So don't worry. Line 100, they've made a change here too. It says loan approval, which requires buyer to sell other real property, shall not be considered loan approval. And the old contract ended there. The new contract says unless Rider V is attached. So Rider V is the sale of buyer's property rider. So if your buyer has to sell their home in order to qualify for the loan for the new purchase, okay, you need to have Rider V. If you don't have Rider V, then they cannot ever say that they have loan approval under this contract. The previous contract, if you had to sell your home to purchase this home, you could never get loan approval per the terms of the contract anyway, okay? In this market, a lot of sellers are not taking offers that have sale of buyer's property contingencies. So you may still just be in the same boat. If you have a buyer that needs to sell their home in order to purchase this one, you really should be advising them to try to get a post-occupancy agreement or something like that, so that they can stay in their home, close, have the money to purchase their new home, and not have to worry about qualifying for loan approval. Because if your buyer has to sell their home in order to close, and they're trying to do a simultaneous closing or something like that, they have no control over whether or not their buyer is going to be able to close. And if their buyer can't close, then they're going to be in default under this contract. Okay. So if your buyer needs to sell their property to purchase and they're not going to have that sale of buyer's property rider, we really need to get on the phone, and you need to have a cover your ass conversation with me, with their lender, just to make sure that they understand that their deposit could be in jeopardy if their home doesn't sell. Their home selling in another state, you know, you don't have any control over that transaction whatsoever. Okay. So some of the things that you guys have to do as agents is really there to cover your ass. You know, we talked about cash transaction. If the buyer is going to get a loan, but you're checking off that it's a cash transaction, you need to have something in writing from them saying that they understand the implications of that. You know, you can't just have a conversation with them and say, yeah, put through a cash offer, and then you have nothing memorializing that. And then later on, when they don't get their loan, they blame you for submitting an offer with the cash box checked off. Okay, so you guys have to think about protecting your license and protecting your broker's license too, so that you're not getting sued by a buyer for something that they asked you to do, you know?
Yeah, I was gonna say that too, because some
Yeah.
buyers say, well, I have the cash. Let's go in
Yeah.
as a cash deal.
So-
And then halfway through, they're like, well, I've been looking at financing. I think I
If
can
you
save
have,
money."
if you have proof of funds from your buyer, that's fine. You can get a cash, you can submit a cash offer. If you're the buyer's agent and your buyer's saying, I want to submit a cash offer and they don't have proof of funds, we really need to have a conversation with them, right? But if they have proof of funds and they decide to get financing after, that's okay. You know, I mean, so what? They can try to get the money from anywhere, but they have to understand that if they don't get the loan, they still have to close. And you've done your work up front to make sure that they have proof of funds. And from the listing side, if you're accepting a cash offer, you better have proof of funds from them. Otherwise, it's not a cash offer, you know? They absolutely do not have to say whether or not where they're getting the money from on a cash offer. And standard L in the back of the contract says that the buyer has the right to get an appraisal done. They have the right to get an inspection, all of that stuff, and the seller has to give them access for it. It does not specify that they have to have the financing contingency to be able to do that, because cash offers can get an appraisal. Doesn't matter. You know, it's just a matter of whether or not they have a contingency. And if they don't have a contingency, well, they have to close no matter what. You know, they can't back out because they didn't get a loan. That's all that section means. Okay. All right, jumping down to line 106. It says buyer shall, upon written request, keep seller and broker fully informed about the status of buyer's mortgage loan application, loan processing, appraisal, and loan approval, including any property related conditions of loan approval. So they added in here upon written request. The previous contract said that the buyer shall keep seller and broker fully informed. Okay, there was no written request needed. So if you're on the seller side and you want an update, you're supposed to put in a written request for it now. Email, hey, what's the update on the loan application? Did you get it in? What is the update on the appraisal? When's it going to be scheduled for? It needs to be in writing. Previously, if you just called up everybody and asked for an update, you're supposed to get an update. From the buyer side, all you need to tell the seller about, or the seller's agent, is a status update. This section is not saying that you have to give your mortgage loan application to them. You do not have to give the appraisal to them. You don't have to give the loan approval to them. Okay, and you never have to give a loan denial to a seller. This is the loan approval section, not the loan denial section. So if you're trying to cancel a contract during the loan approval period and the seller's asking you for a loan denial, you do not need to give them one. All you need to do is say, I don't have a loan denial, but the buyer is not going to get loan approval prior to the end of the loan approval period, so we're terminating the contract. That's it. That's all you need to tell them. And they can fish all they want for more information, but you don't have to give it to them. If you are working with a lender and it's a lender that you don't know, or even if it's a lender that you do know, you need to have a conversation with them before the contract gets underway, telling them from the buyer side, if you're the buyer's agent, hey, don't just get on the phone with the listing agent and start answering their questions. You know, if the listing agent has questions, let's make sure we're on the same page. You don't want a chatty Cathy for a lender. Less is more from the buyer side. I've had listing agents call up lenders and get all sorts of dirt about the buyer's application, you know, what's going on with their loan approval period. And if that lender gives too much information to the seller, that could put the buyer in jeopardy of being in default. Okay, we don't want the seller to say that the buyer's in default if the buyer's not really in default, but maybe the buyer is in default and the lender's basically telling the seller that the buyer's in default. You don't want a lender to do that, okay? There's very little information that the lender is required to tell the seller, so let's limit it to that from the buyer side. Now, if you're on the buyer side and you're asking for like an extension to the loan approval period, or you're asking for the price to be reduced because of the appraisal. Now, the appraisal is within the loan approval period, okay? Let's say it comes in way short, and the only way you're gonna get loan approval is to reduce the purchase price. Well, the seller's not going to reduce the purchase price without seeing the appraisal. So that would be the time where you can give them the appraisal. Okay. I had a buyer's agent one time cancel a contract during the loan approval period, tell their buyer that they were going to get their deposit back, and then the listing agent asked for their denial letter. So they got the denial letter, they sent it over to the listing agent, and then the listing agent and the seller's attorney looked it over and said, oh, well, the buyer's in default, so we're not allowing you to back out of the contract without giving us the deposit. The listing agent and the seller's attorney determined that the buyer was in default because their denial letter said that they did not timely furnish all documents to the lender, which means that they didn't use good faith and diligent effort in obtaining the loan. So the buyer's agent ended up getting sued by the buyer because the buyer had to give their deposit to the seller, and the buyer's agent ended up having to reimburse the buyer for their deposit, and their insurance didn't cover it because the E&O policy said that they were practicing law without a license, because they had no right telling the buyer that they were going to get their deposit back because they don't know how to interpret a contract. So it was a huge cluster, and that broker ended up having to cover the fee for the deposit. And it was, you know, a giant misstep that didn't have to happen because the buyer's agent sent a loan denial letter and they didn't need to. There's nowhere in here that says you have to give a denial letter to a seller. So don't do it. You don't need to. Yeah.
To clarify on this, that's what you said, but so all we need to do is basically tell them buyer will not be able to obtain loan approval.
Yep.
The loan approval date, and that's it.
Yep.
So if the listing agent seller says, I want proof, I don't believe them, we don't have to give them proof.
Nope. You do not.
But the lender and the buyer and myself need to be on the same page.
Absolutely.
They can call the lender, and all the lender would have to say is we can't give loan commitment.
Absolutely. So of course, if you have loan approval, you can't tell the seller, I don't have loan approval, I'm terminating, right? And the lender will never do that. But another reason to be on the same page with the lender and to, you know, kind of refer your buyer to a lender and hope that they choose the one that you're comfortable with. I had a lender I had a conversation with where the buyer didn't have loan approval yet, and the lender would not put in writing that the buyer didn't have loan approval. And I don't know why. And there was no reason why he couldn't, you know, so I said to him, well, does the buyer have loan approval? And he said, no. I said, great. Can you send an email out saying that the buyer doesn't have loan approval? And he said, no. And I said, well, you know, you're really hindering the buyer's ability to get their deposit back right now because you're not saying this. What's the problem? Well, I just won't do that. I said, okay, well, so I had to go back to the buyer and I said, well, your lender's a dick and he won't do this for you. I'm going to put this in writing for you saying that you don't have loan approval, but I can't get your lender to say it and I don't know why. We ended up getting the deposit back. You know, sometimes when this happens, we have to argue for a couple of days. I might, you know, have to step in and start talking to the seller and say, well, listen, the contract doesn't say we have to do any of this, you know? And then the seller wants more information because they want to be able to determine whether or not the buyer's in default, right? But the contract doesn't say that they have to give that information. So if the seller's willing to go to mediation and sue the buyer over trying to figure out whether or not they're in default, go ahead. They're going to have to come out of pocket and start doing that, you know? And I don't think an attorney is going to advise them that that's smart because they have no proof that the buyer's actually in default, you know? And then similarly, you know, the buyer doesn't want to get issued a loan denial because let's say they're going after a house that maybe is a little bit out of their price range, or maybe it didn't get a, you know, the appraisal didn't come in or something like that. If that lender has a denial on record for that buyer, then it becomes harder for that buyer to get an approval the next time around too. So, you know, you don't have to have a denial letter. From the seller side, when you're asking for information, okay, certainly mortgage loan application, that needs to be done within 5 days of the effective date. So you should have a, you know, a timeline. Hey, it's 5 days after, let me find out if they made their loan application. And the seller or the buyer has to give you a status update on that. And the only status update on a mortgage loan application is, yeah, we made it, or no, we didn't make it. And if they didn't make it, then they're in default. The appraisal, same thing. You can ask for updates when the appraisal is going to be, you know, scheduled.
Has been ordered.
Exactly. Did you order it yet? And if they didn't order the appraisal, like within a couple of days of opening up the contract, now all of a sudden you got to get on the buyer's agent and say, hey, get on the lender and make sure that they get this appraisal done, because the quicker we get the appraisal done, the quicker we know whether or not they're going to get loan approval, right?
Well, I do feel like
Question.
even with like with buyers, sometimes they don't, or unless they get through the inspection, they don't feel comfortable
Yeah,
getting the appraisal or
right.
getting this this part moving.
And that's the strength of the lender too. Right. Mhm. Yeah. And there are lenders that are going to wait. There are also lenders that immediately order an appraisal on a rush.
And that's what I was gonna
And
say.
that's the strength of an offer too. So when you're on the buyer side and you have a lender that's not doing that, well, their offer is not as good as a buyer who has a lender that's doing that. And from the listing side, you know, when you're looking at offers and you're talking to the lenders, well, hey, that's a question to ask. Do you guys order a rush appraisal as soon as you open up the file? And some of these lenders, even under the new contract, are still offering 14-day loan approval and saying that they're going to get the appraisal done during that time because they're having that turnaround. Now it's the end of the year, there's holidays, there's all sorts of stuff going on. Appraisals are most likely not coming back, you know, within 14 days. They might be, you know, but they may not be too. So, you know, I have a couple of lenders that are putting things in additional terms that are trying to separate financing from loan approval. And, you know, we'll talk about that in a little bit too. But it's a huge thing.
As a buyer, if you're representing the buyer, are you required to
It's really-
let them know, or just when they ask you?
So under the new contract, you don't have to tell the seller anything unless they put the request in writing. So now they have to put it in writing. So if Ronnie's on the other side and he's calling you up and he's saying, give me the update on this, you could say, I mean, okay, I mean, how difficult are you going to be? But if it's something crazy, you could say, you know, send out an email requesting everything, and then I'll go over it with the buyer's attorney or whatever you need to do. Because, you know, the contract now is saying you don't have to tell the seller anything unless it's written in writing. And then it's also saying you only have to give status updates. You know, you can, as a buyer's agent, you can always hide behind the, let me check with the lender. And also let me check with the buyer's attorney if it's something that you're really not sure about or you're uncomfortable answering, you know? And then loan approval, okay? The seller can ask for updates to the status of loan approval. However, when I'm representing a seller, I always recommend that we don't ask about loan approval until the day after the loan approval period. Because once we get past the loan approval period, the deposit is hard. The buyer can't back out if they don't have loan approval. If we're on day 29 of a 30-day loan approval period and we're hounding the buyer's agent, hey, do you have loan approval? What's going on with this? Did we get it? And you're prompting them to come back to you to say, oh, we don't have it yet, we want an extension, or we're terminating the contract. We don't want that to happen. We want to give the seller options, right? So if we wait until the day after the loan approval period, if the buyer is silent and doesn't say whether or not they have loan approval, now all of a sudden their deposit is hard, but the seller has 3 days to be able to terminate the contract. And in this market, you might have a better offer waiting in the wings, right? Or this whole transaction may have been a mess and the lender is horrible and you don't want to deal with them anymore. And the seller's okay with that. And they're okay terminating the contract. And we just don't trust that the buyer is going to be able to close. So that's an option for your seller. So really good agents that I work with and, you know, advise all the time, they are on top of their files, on top of the deadlines. And if they're on the listing side, they are constantly asking for updates. And you have to be able to constrain yourself and say, no, this doesn't make sense for me to ask for an update on day 29. Let me wait until day 31. And now my seller has options. Exactly. All right. So think about that type of stuff before you start asking for things and barking up a tree that you really don't want an answer to. Okay. But certainly all of this other stuff, ask about, you know, mortgage loan application is the #1 thing too. 5 days after the effective date, you need to know whether or not that application's been made. Because if it hasn't been made, that's a huge, huge red flag, right?
So I have a question.
Yeah.
What, it's probably a lender question, but in short, what is a mortgage application other than, is it somebody who hasn't yet received a pre-approval, or a mortgage loan application is something that happens after a pre-approval process?
You find the house, put the numbers.
Yeah, you can't make the application until you're under contract.
So basically they have everything else besides the address.
Well, no,
Not
not
necessarily.
necessarily.
Okay.
Yeah,
When you're doing
there's
a loan-
paperwork.
When you're doing a loan, you gotta find the house. Once you take that house, then they're gonna really dig inside this person
Right.
to see if this is gonna fit either way or one or the other. And then you submit that process and it goes into underwriting.
Right, so this goes back to asking for desktop underwriting too. If you're asking for a DU ahead of time, that means that you're getting it, that means that the buyer has filled out way more paperwork than just getting a pre-approval letter.
That's why
Anyone can get a pre-approval letter.
I always wondered why the agent put must attach to you.
Yeah,
They want to be bona fide sure that.
yeah, they want
buyer-
to be able to review that too, because they can look at a buyer's ratios to
Yeah.
determine whether or not, and they can have their lender look at it, and a lender can look at a DU and say, these numbers don't make any sense at all for this purchase
Too
price.
risky.
Right, absolutely.
I have a question.
yeah.
What about proof that they've actually applied for the loan?
They do not, well, the lender can't lie. The lender cannot say, yes, they've made the mortgage loan application and they have not. So all they have to give are status updates. But in this case, the only status update you can give on an application is, yeah, they've applied, or no, they haven't applied, you know? So that's an important one to ask about that not many people do ask about. Okay. We're going to talk about now what the buyer's responsibilities are under the financing contingency now. Okay, line 111. If within the loan approval period, the buyer obtains loan approval, buyer shall notify the seller of the same in writing prior to the expiration of the loan approval period. Okay, that's part one. If the buyer has loan approval, they have to tell the seller in writing that they have loan approval prior to the expiration of the loan approval period. The previous contract said that they had to promptly tell the seller. So like as soon as they got loan approval, they had to tell the seller, which really didn't happen, but that's what the contract said. So you now have the entire loan approval period to tell the seller whether or not you have loan approval. And it's not beneficial to tell the seller early on that you have loan approval, because the buyer could end up losing loan approval after. Let's say they lose their job after they get loan approval, but they're still within the loan approval period. They can cancel the contract because they don't have loan approval. Okay. So that's part one. Then it says, or if buyer is unable to obtain loan approval within the loan approval period, but buyer is satisfied with buyer's ability to obtain loan approval and proceed to closing, the buyer shall deliver written notice to seller confirming the same prior to the expiration of the loan approval period. Okay. So option two is we don't have loan approval, but we're still moving forward. Why on earth would we do that? Well, Yanni was asking about this earlier. What if we are sure that the seller wants a 14-day loan approval period, and then we have an appraisal contingency? At the end of the 14 days, all of their financing conditions might be met on loan approval, but we don't have the appraisal. Under this contract, you cannot say I have loan approval because one of the conditions is the appraisal. So now you have an appraisal contingency though. So the buyer is comfortable saying, well, I don't have loan approval, but I'm confident I'm going to get it. I'm moving forward. And then you have an appraisal contingency. And if it appraises low, well, the buyer can terminate the contract based on the appraisal contingency. So that would be a scenario where you would be saying, I don't have loan approval, but we're moving forward. Okay. Or maybe some of the conditions on the loan approval are very easily met, and the lender is very confident that the buyer is going to meet them, but they just haven't met them yet, and they're just waiting on something. Okay, that might be a scenario where you're going to move forward without loan approval, but that warrants a pretty long conversation with the lender and the client to make sure that everybody's on the same page.
Like if they're just waiting for like a letter or something like that.
Yeah.
So,
Gift funds, maybe something like that, you know? Okay, and then on line 115, the third option is if buyer is unable to obtain loan approval within the loan approval period or cannot timely meet the terms of loan approval, all after the exercise of good faith and diligent effort, buyer may terminate this contract by delivering written notice, and then they get their deposit back. Okay, so 3 options. Yes, I have loan approval. No, I don't have loan approval, but I'm moving forward. Or no, I don't have loan approval and I'm terminating the contract. Okay. I've created and worked on with Jordana a form for you guys to be able to fill out and have your buyer's initial that has these 3 options on here, because you need to put something in writing to send over to the seller prior to the end of the loan approval period. If you don't put something in writing and you are silent, this is what happens. Okay, line 120. If buyer fails to timely deliver any written notice provided for in paragraph 8B3 or 4 above, which is what we just went over, the 3 options, to seller prior to the expiration of the loan approval period, then buyer shall proceed forward with this contract as though paragraph 8A above had been checked. What's paragraph 8A? Cash. Okay. As of the effective date, provided, however, seller may elect to terminate the contract by giving written notice within 3 days. Okay, so if the buyer is silent, 2 things can happen. The seller can terminate the contract, same thing as the previous contract said. Okay, they have 3 days to terminate the contract. Or if we're moving forward as a cash transaction, which means that the buyer will not have any benefits that are in the financing section. This is different from the previous contract. And from a legal standpoint, it's a huge difference, because the other protections that the buyer has, you guys don't have any control over. Okay, so for instance, on line 128, it says that if the buyer has passed their loan approval period and can't close, and it's because of property related conditions of the loan approval that have not been met, then the buyer can terminate the contract. But if the buyer was silent and did not say whether or not they had loan approval, then this section doesn't apply anymore. And you no longer can back out for property related conditions, which you guys don't have any control over whether or not the lender at the 11th hour says, oh, these property related conditions haven't been met, or we just got the lender questionnaire back from the condo association and we can't fund this association. You have no control over that, right? So if you were silent and that happened, your buyer's going to lose their deposit, and then they're going to blame you for losing deposit, and they might be right to blame you. You could get sued for that.
So as long as
Okay.
we make some type of statement if we're moving forward or not,
Yep.
we should still be able to have access to
Yes.
those loopholes for us.
You have to put something in writing. It's either I have loan approval and I'm moving forward, I don't have loan approval and I'm moving forward, or if you're terminating the contract, you're terminating the contract. Okay. The other section that this applies to is section 5, the TRID clause. Okay. This section only applies if paragraph 8B is checked. But if you were silent, then we operate as if paragraph 8A is checked. So if you have a lender, everything is going smooth throughout the entire transaction, you're silent as to whether or not you have loan approval, and then the day of or the day before closing, the lender says, oh, I need to disclose the CD, I haven't done it yet, or maybe I need to redisclose it because I made a mistake earlier or something like that. If you have a savvy seller or seller's attorney and the lender is trying to ask for this 3 days extension, I've already told my team we need to be on the lookout for this, right? Because from the seller side, I'm going to say, no, this is a cash transaction. You don't have the right to do this. And I might try to renegotiate, or I might try to back out of the contract if I'm the seller. So you can imagine a scenario where the seller gave a credit to the buyer for like $5,000 or something like that. Now, all of a sudden, the buyer is coming to the seller and saying, I need an extension. The seller may say, okay, fine, but I'm not crediting you the $5,000 anymore. So that's another scenario where you've taken an opportunity for your buyer to negotiate or, you know, or back out of a deal or extend a deal and over something you have no control over. So from the buyer side under this contract, when there's financing, it's super, super important to make sure that you put something in writing at the end of the loan approval period. And if it's not, I have loan approval, then there's got to be a discussion with the client and the lender and potentially me as to what the implications of moving forward without loan approval are, or you're terminating the contract. Okay, yeah.
If you're putting it in an email and it's in writing, I mean, does that need to be always forwarded to the title company that?
I always recommend like copying the closing agent on it so that everybody has it, you know, but I mean, technically you only need to email it to the listing side,
Right.
you know?
That becomes an issue you have.
Yeah, you know, and certainly things can be caught too. If you're emailing somebody and you have the wrong email address, then you never sent it to the seller, you know?
Right.
So an extra set of eyes on that might be, oh, hey, you know, you sent this to the wrong person, or maybe we forward it or something like that. You know, you have to be very, very careful about notices and formal notice. And then I always follow up, you know, if I'm emailing something that's formal notice, whether it's termination or an addendum that needs to be signed. I mean, I'm either calling or texting with the listing agent to make sure that they've got it and something's going to happen. Okay. Yeah. The document that we created should be in the system. I know Jordana and I worked on it last month sometime after we did the last training, so it should be in there. It's a buyer's loan approval document, and there's 3 options on it, and you want your buyer to initial one of the options. And if they're initialing, I don't have loan approval, but I'm moving forward, you guys are safe because presumably there's been a conversation with the lender, you know? So, and then you could just take that document and send it right over to the seller too, so that you don't have to create something else and, you know, but you don't want to be in a scenario of where you're sending an email to the other side on behalf of your buyer saying they have loan approval or they don't have loan approval, but we're moving forward. And you've got nothing from the buyer telling you to do that, because if they lose loan approval or they can't close for whatever reason, they're going to blame you guys. So this is about covering your ass. Yeah. Does anybody have any questions about this section? This is the most important thing that we're going to cover.
It's kind of scary.
Yeah.
But as long
Yeah.
so if you have a buyer and you're financing, you just have to remember, you gotta say something.
You have to say something.
Before the end.
So under the previous contract, the worst thing that could happen is that the seller could back out of the contract if you were silent, right? And that could be a pretty terrible thing too. If you're on, I had a scenario where we were actually representing the sellers, okay? And everything was going fine. The sellers were getting divorced, so they were like heated, but we were like representing the couple themselves in the transaction for sale, okay? All of a sudden, the day after the loan approval period, everybody in the transaction got a letter from another attorney that represented the sellers saying that they were terminating the contract because the buyers were silent. These people were sitting around waiting to be able to do that. Then what they ended up doing, this was $1 million transaction. What they ended up doing was negotiating with the buyer's agent to not have to pay their commission. So they ended up going back under contract with the buyer, closing, okay? And then the buyer's agent didn't get their $30,000 commission.
So it was either that or the
And the buyer's agent had to do that because the buyer was just going to sue them for losing the transaction for them. And then the sellers were happy with that because they saved $30,000 and they weren't going to get a better deal than that, basically. Yeah.
Just to be clear, because this is so.
Mm-hmm.
Let's say that my client, okay, have a very good relationship with my lender, so I can talk to them.
Yep.
Midnight or any time, because he knows that if I call him there, I'm there. And I talk to him. Let's see that it's
I love that.
21 days.
Yep.
And the date 20, or maybe
Mhm.
earlier. I talk to the lender and see where we are.
Mm-hmm.
And it's gonna say, okay, we don't have a loan approval yet. I take that document and check one of those boxes. And then
Yep. And have your buyer sign off on it.
Right.
Okay. So, I mean, your fourth option is to ask for an extension to the loan approval period, but the seller doesn't have to give you that, which is why I don't want that option on your form, because I don't want you guys to just fill that out and send it over and be like, okay, I'm done. You know, yeah.
Questions. I always, not always, but we always get Also, the extension,
Mhm.
sometimes we need them.
Yeah, if your lender is telling you, and it's, lender, whether you trust them or not, if they're telling you we don't have loan approval, then you either need to extend the loan approval period or cancel the contract.
Right.
They have to really convince you that, yeah, we don't have loan approval, but we're gonna get it. Well, why are we gonna get it? What are we missing that you can't say today that we have loan approval? For instance, the example of the appraisal. If everything else is done and we're just waiting on the appraisal to come in, at least we know that that's the only thing we're waiting for. So either at that point, we're getting a loan approval extension to wait for the appraisal, or we're gonna add in an appraisal contingency if the seller allows us to, or we can't move forward, because if the seller's saying, no, I'm not giving you any of those extensions, and there's no appraisal contingency, and we don't have the appraisal back, we have no idea what the appraisal is gonna say. It could come in 100,000 short, and then your buyer's on the hook for it,
She's like, okay.
So what is loan approval? There's no actual definition of loan approval other than financing is completed and the appraisal has been done. Every loan approval has conditions on it. So the question is, are those conditions easily met by the buyer or not? And at the beginning of a transaction, the conditions that are on a loan approval that need to be satisfied are very long. And then by the time you get to the loan approval period deadline, they should be very short. And there's always still going to be conditions. It's just a matter of what are those conditions, and property related conditions often have to do with insurance and things like that. If you're not getting the 4-point inspection for the insurance done early on during your inspection period or during your loan approval period, that's a problem, because we don't want to find out the day before closing that we're trying to bind insurance and we can't. That's a huge problem that happens all the time, and it could be easily solved if we just get the 4-point inspection done earlier, or we try to get the insurance done during the loan approval period. And then one of the scenarios that happens is there will be a property related condition related to insurance. Okay, the lender is assuming the insurance policy will cost, let's say, $3,000. But then at closing, we find out that the insurance policy is going to cost like $7,000. That could totally screw up the buyer's debt to income ratio, and that could make them lose loan approval. If I'm on the seller side, I'm not accepting that that's a property related condition. To me, that's a financing problem. You guys didn't figure out how much it costs for insurance, and now your financing is screwed up. That to me has nothing to do with the property related condition. If I'm on the buyer side, I'm going to argue it's property related condition, but it's a gray area, right?
It's the hat that you wear.
It's a gray area because it doesn't say anywhere in this contract what a property related condition is. It's not defined anywhere, and there's no court case that outlines what property related conditions are. So it's just an argument every single time. So we don't want to rely on that section that's a gray area to be a fallback for us. Let's get our stuff done during the loan approval period, because that's very clear. The buyer can back out during the loan approval period if they don't have loan approval. Not a big deal, right?
So right now on this contract, we're looking at the inspection period and the loan commitment period to be able to really kind of back out. And the
Yes.
final walkthrough properties.
Typically the buyer in this contract has two contingencies. They have the financing contingency and they have the inspection period. They may also have like a condo approval contingency or something like that, but that's not on every contract.
Sorry, I just have a question. Do you feel that lenders, like our lenders more are aware of these situations? And are we now expected to be in touch more and request like more updates than we were before?
Yeah.
Yeah.
Yeah. Now, whether or not the lenders are aware of it, the good lenders are aware of it by now. I mean, but up until like late October, there were plenty of lenders that had no idea.
I think our challenge is that it's really difficult to get lenders. All of us know that. It's like an external source that we have very little control.
Yeah.
And this new contract essentially means we're at their mercy.
Yeah.
Whether or not they're ordering the appraisal on time. If that's
Right.
the lender,
We're always at their mercy anyway, and
We are.
this contract is making it even more so.
even more.
And the appraisal, the lender doesn't even have control over the appraisal. They only have control over whether they order it and whether they order it on a rush, which by the way, a rush appraisal is only like $200 extra. So if you have a lender and they're saying, oh no, we're not going to do a rush. Well, they're putting the deal in jeopardy by delaying everything. And it's not that much more. Yeah. Kyle.
So I guess the best thing to do as a CYA is just make sure that you mention all that stuff to the lender well in advance, so that if you are going under contract, hey lender, I know you're in New York, Minnesota, wherever, but can we get X done at this time? Can we get X done at this time? That way, if it doesn't happen, at least they're coming after us. Like, no, we have the email thread to show that we
Right.
made it known to make those attempts.
And there's two strategies, because we're in a seller's market right now too. If you know the lender can't get something done, you either are going to account for that in the beginning of the contract before you get under contract by having an appraisal contingency or a longer loan approval period, or the property might be so competitive that you might be putting in a good offer and then trying to deal with it later. Okay, we come up at the end of the loan approval period and we don't have the appraisal done, so we extend it, or we do an appraisal contingency, you know. But you also don't want to be spinning your wheels. If you know the lender can't get something done and you're entering into contract, and then you're just going to be asking for an extension later, all of the listing agents are out there are getting a million offers. They may just say no and go with a different offer, you know. So there's a fine line there between what's making my offer the most attractive versus what's just unrealistic. And then now all of a sudden you're spinning your wheels with your clients too, because your clients aren't going to be happy with that either. So they're unhappy with not being able to get under contract on the million properties you went to go look at to begin with, right? But then they're going to be unhappy if you enter into a contract with a 14-day loan approval period and they can't get loan approval in 14 days and they can't get the appraisal done in 14 days. And then the seller says, well, fine, just cancel the contract. You know, so it's a tough market for buyer's agents right now. You have to think about all of those things.
So, also, I want everyone to know all of these things that are happening with the lender. We will talk to Mike and his team to make sure that they're on top of it.
Yeah.
So that anyone who we do send over to MEP.
Yeah, and Mike's office is awesome. You know, they do a very good job, but we have to be on the same page.
Loan commitment in 15 days.
Yeah.
My last deal, and I wrote it in additional terms, and that's how we got it.
Yeah.
So you
Oh,
can get
that's how you got them to accept the
Yeah.
offer.
Because I basically just wrote, and then I confirmed with Kyle beforehand, but
Then you could get it done, then, okay.
Yeah. So
Yeah, and I've been just telling people, like, you know, a couple of years ago when the market was different, it was normal for your lender to suggest, like, wait until you've done your inspection and then tell me and I'll order the appraisal. I've just been telling people, like, consider your appraisal as sunk cost.
Yep.
And just order it immediately when you put the application in. And like, my last deal was FHA, we got it approved, appraised, and done in 12 days.
that's awesome. Yeah. And you can very well do that. And it depends on how, you know, how efficient the lender is being. And you guys ultimately, you know, you guys get paid at closing. So you don't have any control over the lender though. But if you're on the same page with them, then at least you know what's going on, you know?
I think also, TJ, like you said a minute ago, as when we represent buyers, we have to set the expectations a little bit differently now. Like what you just said, Tom, about them expecting the appraisal is a cost that we're just not eating deal first. But let's order it in the beginning so we're not stuck waiting for it. So
Exactly.
it's about expectations, I think.
I just help
with
people
this
put
new
the
contract.
application in order to appraisal.
Right.
Yeah. The only time I would say you don't really have to do that is if you have an appraisal contingency. Because you know that whenever it comes in, well, we're going to deal with it based on what the contingency says. The thing is, though, the earlier the appraisal comes in, the earlier you can deal with that problem if it does come in low, right? And then if you are waiting on an appraisal, then you have this problem of whether or not you can tell the seller that you have loan approval. And if you get it later, you have to say, I don't have loan approval, but we're okay moving forward, which is another risk for the buyer to take. But if you have an appraisal contingency, okay, fine.
Very important, I will say, no, sometimes they're in New Jersey, you're living in.
They have no idea. Yeah. They have no idea.
Now more so than ever, even on the listing side and the buyer side, we need that relationship. So if somebody says, I'm a buyer and I'm like, I'm committed to my lender, you as the agent say, that's fine, I need to talk to them. So then when you speak to them, you're setting the expectation, appraisal has to be ordered and so on, or like you said, Maria, have them work with somebody that we know. But even, like right now with the listing, we got an offer on, we're not going to execute the contract as the seller until I speak to the lender and know that this guy is qualified, it can actually close and meet all the deadlines.
Right, and then here's the other thing, because of that, it's a seller's market. We are having so many transactions fail because the buyers are making offers that they can't keep, or that it's getting extended, and then your seller, who was so happy with the million offers they got on the property, all of a sudden is not so happy because we can't get one that will actually close. So you really do need to vet the offers that are coming in to figure out what is serious and what is not serious. Sometimes accepting something that is a 21-day loan approval versus a 14 makes more sense because the 14 is just offering whatever the heck they can to get in, you know, and you just don't know if you haven't talked to that lender and you don't know who they are. You know, we're having that happen all the time. And then the cash transaction, it's great to have a cash transaction, but if they're getting a loan and then they don't actually have proof of funds, that's a huge problem. You know, I also have agents that are accepting, you know, having a finance transaction from the listing side is not always bad. You know, you could get a much higher offer that's financed than a cash offer too. And so you have to set that expectation with your seller too. Like, well, we have this offer, it is cash, but it's not like loans don't close. Of course loans close, you know, so if you know who the lender is and you vetted them and everything, it could be a better offer to have a finance deal. But the buyers do have contingencies. There's that opportunity for them to back out if they don't get loan approval. So yeah, it's a crazy market right now. I also have some lenders that are suggesting, well, we could put in the additional terms that, let me just show it on the screen. So section 1 of the loan approval period is defined as financing. And then section 2 is defined as appraisal. I have some lenders saying, okay, put in the additional terms, the financing prong of the loan approval will be done in 14 days and the appraisal, you know, will be done in 21 or something like that. That's a possibility, but it's also kind of confusing because you have a loan approval period that's going to be whatever, however many days, 21, 30 days, and then you're putting something that might conflict with that in the additional terms. So if anyone's recommending doing something like that, we need to talk about it to make sure that we don't have conflicting terms in the contract, because it's going to be interpreted against whoever put that term in there. Okay. I would recommend if you're going to have a short loan approval period to have an appraisal contingency, because then at least we can that's how we would take the appraisal out of the loan approval period. And then at the end of the loan approval period, if the only condition that we have is appraisal, then we know that we're kind of covered because we have the contingency. Okay.
Well, what if you don't? Would you just extend the loan approval period? And what if
Yeah,
you don't?
you'd have to, because you can't get loan approval under the contract, and then you also have no idea when the appraisal is going to come in at.
Right.
So if you don't have a contingency, there's no protection there. And if the appraisal is really screwed up and comes in way low, your buyer's on the hook for it.
Okay.
And then just because we're talking about appraisal language now too, the language that says the buyer is willing to pay X amount of dollars above the appraised value up to the purchase price is not good language. It ends up in disputes all the time because the buyer may be assuming that the seller's going to reduce the purchase price and they're going to get the house for less if it appraises low. And the seller is assuming, well, we're not bound by this language because it just says what the buyer is willing to do. Okay, so at the outset of the contract, if we're going to have appraisal language, we want to figure out, one, is the seller willing to reduce the purchase price based on the appraisal? And they might be. It depends on the situation. If we're having an offer that's well above list price, usually the seller is just concerned that they absolutely get list price. So then we can write the appraisal language to make sure that they absolutely come away with list price. Okay. And then there needs to be a floor on it too. So we want to make sure that if the appraisal goes too low, that the parties are able to renegotiate too. And that might actually help a buyer get under contract because the seller feels like they're protected too. And that could actually make your offer stronger, even with an appraisal contingency. Okay. All right, next section we're gonna talk about is in the standards. Or no, I'm sorry, we're gonna talk about section 9F first. Okay, section 9F is for special assessments. This section has nothing to do with the condo assessments or HOA assessments, okay? This is for public body assessments. Public body assessments are found in the non-ad valorem taxes section of your seller's taxes. So if you are a listing agent, you should be checking the trim notice for your seller's taxes to begin with, because you should be figuring out what their net is going to be on a sale, right? But if you look at the non-ad valorem section, you're going to see fire assessment, stormwater assessment. You might also see some sort of public body assessment. And depending on what it is, it could have to be paid off prior to closing. Okay, so in Delray, for instance, there's a couple areas where they're adding in like sewers and things like that. Those assessments have timelines that the sellers have been given, and they probably show up on title, but it's possible that they might not show up on title. And so, hang on a second, because this is the second time this person called me and they just don't know that I'm in a training. Okay, so for instance, if there's an assessment like that for sewers, or in Parkland, there's the North Springs Improvement District, which has a stormwater assessment, or it might just be regular water. Those things could have to be paid off prior to closing by the seller. Under the new contract, they've added in special districts on line 201. And if it's a special district or a community development district, then it doesn't have to be paid off prior to closing. Okay. So the North Springs Improvement District in Parkland counts as a special district. So under the old contract, it had to be paid off prior to closing. Under this contract, it doesn't have to be paid off prior to closing. And then there's also a lot of special districts in Miami. So they would fall under this section now, to where this just doesn't even apply anymore, which is great. But you need to be aware of those things, and you need to figure out whether or not it's something that's in a CDD or a special district. Or from the listing side, just make sure that 9FA is checked off. Then you don't have to deal with it. If 9FB is checked off, there could be a special assessment that your seller could be responsible for paying for prior to closing. And if you allow them to sign that contract and the closing agent knows that there's something they have to pay off prior to closing, then they're going to be pissed off at you. Okay. And it could cost thousands of dollars. Now, PACE loans and Y-Green payments will also show up in the non-ad valorem section. Those are not special assessments. Those are mortgages, and those always have to be paid off prior to closing. So if you have a seller that put in windows or a new roof or something like that, solar panels, and they got a PACE loan, and they're dealing with Y-Green, they have to know that that has to be paid off prior to closing. Okay. And there's a new PACE disclosure that we'll go over at the end of this too, so you guys can fill that out if there's a PACE loan. Okay, now we're going to go to section 18. We're going to jump down to 18O. Okay, line 531. All notices must be in writing and may only be made by mail, fax, personal delivery, or email. It used to say electronic media. Okay, so they've taken electronic media out and it's just email now. So a text message does not count as formal notice. So if you're on the buyer side and you're texting the listing agent and you're saying, hey, the buyer is terminating the contract, that doesn't count. It has to be an email. Okay. Yeah, so that's a huge deal, because loan approval period, inspection period, anything that you have to put the seller on notice for, if you're just texting back and forth late at night, whatever it is, if you don't take the time to put that in an email, it's like you're saying nothing. All right, so be very careful of that, and just remember, no texting.
So,
Yeah.
question. I know before, like, if we had, conversations with the listing agent and they agreed to some stuff, whatever, and we were texting it, we could use that as like documentation no longer.
Well, technically, any outside communication, whether it's in writing or not, if it's not a signed agreement between the parties, it wouldn't be considered, it's what's called parole evidence, which is outside the four corners of the document. So the four corners of your real estate contract are the real estate contract, everything that's written on that page, and then any addendum that's in writing and signed by the clients. All the text messages and the emails and everything like that, that generally is not supposed to be included when interpreting the contract. So if there's a dispute between the seller and the buyer and you're going into court, the judge is looking at the contract, and then it would be a very special exception for him to or her to look at the parole evidence, which would be
Outside.
the emails and the text messages. Usually it's only looked at in extraordinary circumstances like fraud and things like that, or if the contract is super unclear, or if the contract references something that's outside of the contract. So you don't ever want to rely on, okay, yeah, we came to an agreement and it's via text or via email. If it's not in an addendum to the contract, then it's not part of the contract. Okay, but now we're talking about notice, so formal notice saying the buyer's terminating the contract, that's not part of the contract. That's a notice. And the contract's telling you how to send notice to the other side. And this new contract is saying you can't do that by text message. It has to be by email. Okay, we're going to talk about section 18F now, which is time. Calendar days are used in this contract. Okay, so we count days by calendar days, not business days. They've added in here based on where the property is located. So if we have a seller who's out of the country and they're signing the contract and they're in like Australia, it's tomorrow in Australia, right? So if their contract, if their time signature is date stamped for tomorrow and the contract is delivered back and fully executed to everybody, it's still going to be dated today. That's the effective date because the property is in Florida. So we're going to use the Eastern Standard Time Zone. We're not going to use Australia time. Okay, so that's something to be aware of if you're dealing with somebody that's out of the country. They've also taken away the 5 p.m. deadline here. So if you had a deadline that was the inspection period or the loan approval period or something ended on a weekend or a holiday, it would go to the following business day at 5 p.m. Now it's just going to go to the following business day. No more 5 p.m. It also does not say business day here, but they still mean business day. They're saying the next calendar day, which is not a Saturday, Sunday, or a day on which a national legal public holiday is observed.
So they can
Okay.
they can get whatever at like 9, 10.
Yep.
12.
So under this contract, if you have your inspection period end on a Sunday, it's going to go to the following Monday by midnight, unless the Monday is a holiday. Okay, then it's going to go to Tuesday. Yep. Whatever the next day is, that's not a Saturday, Sunday, or holiday. Okay.
But if holidays on a Sunday, does that mean Monday's the third and then goes back over to Tuesday?
Yes. So for instance, this year we had July 4th on a Sunday, and then we observed July 4th on July 5th, which was Monday. So that became the holiday. Okay. So rule of thumb is any day that banks are closed is a national holiday. Okay. So Thanksgiving's coming up, that would be a national holiday. Black Friday is not a national legal holiday. Okay. That being said, my office is closed on Black Friday.
Just to let you know.
That is the only day of the year that banks are open, that we are closed. Okay. Sometimes deposits are due on Black Friday. If you have a deposit that's due on a Black Friday or something like that, we'll deal with it, But yeah, we're closed.
All right, the fact that Christmas
It's
is
not
on
a national holiday. Right?
Yeah, Juneteenth is a new holiday that has been added this year. So we now have a new holiday in June. And I believe is it June 17th? Does anybody know? 19th? June 19th, yes.
Christmas is on a Saturday.
Okay, I have asked my bank twice already whether or not they are closed on Christmas Eve and New Year's Eve, because Christmas and New Year's are on Saturday. And I do not have an answer from them as to whether or not they're closed on Christmas Eve and New Year's Eve. And I ask this because it's very clear from the statute that the day before a Saturday is supposed to be a national holiday. Okay, but last year, 2020, July 4th was on a Saturday, and all the banks were open on July 3rd, and I don't know why. But this year, on July 4th was on a Sunday, and all the banks were closed on the Monday. Yeah, so I don't want to say yet that Christmas Eve and New Year's Eve were closed, because I've literally asked twice and haven't gotten an answer yet, and I don't know why I don't have that answer. So I'm thinking that it's going to be closed, but you know, yeah.
They didn't close Christmas. I was gonna say if they didn't close Christmas Eve, were they gonna go over? to
Yeah,
Christmas?
and that it's super important too, because at the end of the year, people want to get closed for tax purposes and for homestead purposes. So do not have a closing date on December 31st. Never do that anyway, because if there's a problem and the closing can't happen that day, well, then everybody's going to be pissed off. Okay. But this year in particular, banks might be closed, which means we may not be able to actually have the closing on the 31st. Okay. So don't put any closings on December 31st. You know, and similarly, it's not great to put a closing on like December 26th or 26th is a Sunday this year, but December 27th. I mean, lenders are coming back from a holiday. People take vacations and stuff. It's not a great idea, you know. It's doable, but you know, most of the time we're able to do anything. But like Jordana said earlier, we're at the mercy of the lender. We, on holiday weekends especially, lenders take off, their offices close at 3 o'clock, sometimes earlier. You know, we've dealt with that. July 4th weekend this year was a huge one where people just stopped answering the phone after 3 o'clock. So it was terrible. You know, we're there in the office, we're sitting around waiting for stuff to happen and nobody's answering us, you know, so you have to be mindful of those things. You know, the more transactions you do, the more you realize having a closing on a Friday is not the greatest idea in the world. Having a closing on a Monday is not the greatest idea in the world. If you can have a closing exactly on a Tuesday, Wednesday, or Thursday, as long as it's not Veterans Day or Thanksgiving, good. Those are generally like the best times, because if there is an issue, usually people aren't that upset about moving it to the following day, you know. And if the following day is a Thursday or a Friday, okay, fine. But if you're on a Friday and the following day is a Monday, people have scheduled moving trucks, people, you know, maybe they have to stay in a hotel over a weekend or something like that. It's a huge pain. So do yourselves a favor and think about when your closing dates are set for first. Don't just put the 15th or the 30th or the 31st. Yeah. And the 15th, we'll have 1 million closings on the 15th because everybody writes that on their contract. Like, oh, I'll do the middle of the month instead of the end of the month. And like everybody does that. So just be mindful of that stuff. Yeah. Okay. Force majeure. They have added in on lines 443 and 444, civil unrest, governmental actions and mandates, government shutdowns, epidemics, and pandemics. Okay, so COVID, pandemic, epidemic is officially considered a force majeure under this contract, as are government mandates and shutdowns. They have also added in the word right on 439 and 440. They used to only have obligations. So what is the difference between a right and an obligation? Under the contract, the buyer would be obligated to make their deposit within 3 days after the effective date. The buyer would be obligated to close on the closing date. Okay, those are obligations, something the party has to do. Okay, a right under the contract might be the buyer has the right to inspect the property. The buyer has the right to get an appraisal. Okay, because these things are now added into the force majeure section, there's different scenarios that can happen that we've never been affected by before. So let's say a hurricane happens and all the power is down, people cannot make electronic transfers of money for whatever reason, and they can't get to the bank. Okay, if that happens when a buyer's deposit is due, then the buyer can extend their obligation to make the deposit, and they would extend it for a reasonable time after the hurricane no longer prevents them from making the deposit, which might be like 2 or 3 days, something like that, okay? But in no event may that be more than 7 days, according to this section, okay? Now that rights are added to this section, let's say that there is civil unrest and there's a bridge that's being blocked by protesters, and that's the only way to get to the property. If the buyer's inspection is scheduled for that day and the bridge is being blocked for multiple days and they can't get the inspector to the property, under this section, they may be able to extend their inspection period until the civil unrest no longer prevents the inspector from getting to the property. Or let's say the seller or the buyer contract COVID, and so they can't sign their documents because we can't in good conscience send a notary to them. Seller, it's a little bit different because we can do remote online notary, so nobody actually has to be sent to them. But for most buyers and lenders, they have to sign all their documents with a wet ink, you know, so that might be a situation where a closing date could get extended because the buyer has COVID. That's an interesting one. Although we've done drive-by closings, we've handed off documents to buyers, had them sign it and then hand it back to us, you know, but we never actually had anybody that was confirmed to have COVID do that. So we actually haven't even dealt with that situation. It's an interesting one. So that's the force majeure section. Hopefully we don't have to deal with it too much, but want you guys to be aware of it. If there is a force majeure situation that you're involved in, I recommend just getting an addendum that everybody agrees to, so we don't have to deal with the interpretation of the force majeure section. If everybody's pretty clear that something that's outside of everyone's control is affecting a date, let's just agree to change the date, okay? And then if that situation is still affecting the new date, then we'll deal with it then. So that's the rule of thumb for the force majeure. Okay, we're gonna jump down to the 2 addendums now too. So the first one is the seasonal and short-term vacation rental addendum. So it says the seller may or may not, after the effective date and prior to closing, enter into new or renewal seasonal or vacation rental occupancy agreements at market rate and terms for occupancies of the property by third parties after closing. So this deals with the seller entering into a seasonal or short-term rental that would extend past the closing date, okay? Because then it affects the buyer. If the rental ends before the closing date, the seller has the right to do that because it has nothing to do with the buyer, okay? So if you check may and the seller has the right to do that, then the next part says it will only be with buyer's prior approval or without buyer's prior approval. If you have the buyer, you want it to be with buyer's prior approval, okay? And it depends on the situation. The buyer may be okay with the seller entering into new seasonal rentals, okay? But of course, they'd want to approve them to make sure that it's not under market value or something like that. But if the buyer intends on going into the property and renovating it, for instance, they may not want to have the seller have that right, okay? So that would need to be negotiated prior to entering into the contract. And then the second part of this addendum deals with management agreements. The buyer is obligated to follow the terms of a management agreement for all of the rentals that extend past the closing date. It doesn't mean they have to keep using the management company for new rentals, but they have to continue using them for the rentals that are already there and in place, okay? My recommendation is always have the buyer consult with the management company to make sure whether or not they're gonna go with them. And if they are gonna go with them, then we could do an assignment of the management agreement at closing, okay? If they're gonna go with somebody else, fine, but they still have to deal with the previous management company for all the people that are still there, okay?
For the people currently there, so what if the property, because some of these property managers actually schedule
Mm-hmm.
the rentals?
Yep.
So what if I have like a rental that they schedule like in a month?
Yeah, and that's fine. But you
So
still
it's
have to,
still-
yeah, because it's already scheduled. It's on the books.
Mm.
Because you have to abide by the terms of the contract per this addendum. Okay, so they're protecting the management companies there.
Sorry to interrupt. I have a walkthrough, somebody
Yeah.
behind me with a black car. And I need to leave.
Okay, we're almost done anyway. So,
I need to leave.
someone with a black car is behind Maria.
That's me.
That's you. Okay. The last thing that we're gonna go over is the PACE addendum. We talked about this a little bit before, but PACE loans, Y-Green, they have to be paid off prior to closing. They're mortgages. Okay, I have sellers all the time tell me, my lender told me that the buyer can assume this. Yes, the buyer can assume it, but they don't have to. And there's no lender in the world that is gonna be subservient to a PACE loan on it, okay? And it says that right here in the middle of the document. It says, in the event buyer is obtaining a mortgage loan to purchase the property, be advised that most mortgage lenders will require satisfaction or release of the PACE financing from the property, okay? There's no lender that's gonna say, I will be junior to the PACE loan, and the PACE loan is never gonna be junior to the mortgage, okay? They're gonna want it to be paid off. So that lender that's going in there and telling the seller that the buyer can assume it, yes, it's possible for them to assume it, but it's never going to happen. The only scenario when that happens is when there's a buyer who is cash and it's been negotiated that they are going to assume it. But I don't know any buyer that would want to do that, to be honest. When you are listing the property and there's brand new impact windows in there or a brand new roof, generally you're listing the property based on it having these new things there. So the purchase price includes those new changes. So then the seller should be taking the money from the purchase price and paying off the loan that they took out to actually get that stuff done. The buyer is not making an offer assuming, oh, I'm going to get this house with brand new windows, and then I have to keep paying for the windows afterwards after I just paid market value for the house. Nobody's doing that. Okay, so the seller needs to have realistic expectations. I probably have that conversation like once a month with sellers. So please be aware when you are doing listings, whatever questionnaire that you guys have for sellers, make sure you ask about stuff like that. And when you are looking at a property, you should be tipped off by these things like new impact windows, new roof, solar panels. Those are the types of things that people take out loans for to pay for. So ask about those. All right. That's pretty much it. Any questions?
We don't need to have, do we have to have this?
You do not have to have the
What are
PACE
additional
disclosure.
terms, if anything, right? That's sufficient.
Yeah, so the PACE disclosure, I think, is actually more for sellers because it's the sellers always that are surprised that they have to pay something off at closing. You know, the buyers really are not going to be affected by this because they're not going to have to assume it ever. Questions? Anybody? Anybody at home? Questions?
That was actually my next question. So
Roni?
doing our listing presentation, right? And we're going over, we just had a conversation about FERPA and making sure people who there are more naturals and not, like all these things. Should this be something that obviously we'll kind of go down through and like, did you just get these windows? Yes, I did. Are you currently financing them? Yes, I am. Okay, we might have to, you have to kind of present this because this is, somebody's got to pay this, so.
Yeah.
They're aware that they're going to be paying for it, or do you think it's just something that we should probably put part of the presentation?
I would just always ask sellers whether or not they have a PACE loan or something like that, because even if it's not like new windows, if they're like 5 years old, they could still have a PACE loan on there for it. But the thing is, you'll know if they have the loan, if it's old, because you could look at their taxes,
What
you
about
know?
like construction liens and stuff like that? I mean, obviously, I don't figure that out. I just want to know. If it's
Yeah.
something that's gonna be coming,
So,
they have to pay off.
like construction liens, the whole thing is construction liens and PACE loans are title issues anyway, so they're gonna come up on title. They're just like mortgages. And when you're doing a listing presentation, it's always something you guys should be asking about. And not just because of it being a title issue, but when you're trying to figure out that seller net and how you're gonna price the property, if you don't know about all of that stuff, you're not gonna be able to give them an accurate number, you know? So it has to be, it should be part of your listing presentation, absolutely.
Just cut my ass.
Yeah, and same thing with all the personal property stuff, you know? The TV mounts, the thermostats.
Big things, because especially if you're like.
Yeah.
These people had TVs like in every single wall.
Yeah.
Now there's no more TVs and it's, they're all holes in the wall.
Yeah, absolutely.
Because you can actually, would you be able to, and I just want to know, because in your final walkthrough, it's basically says you find a property, like different condition as you left it from the inspection period.
Yeah.
Those holes in the walls are technically.
Yeah, I think that's why they put the TV wall mounts in the personal property section, so people don't have to deal with that anymore. But, you know, if what Roni's saying is in this section 9A of the contract, is the as-is maintenance requirement. At the end of the inspection period, once you guys have negotiated credits and things like that, the seller has to keep the property in the same condition as it was at the end of the inspection period. Okay, so all this stuff that we're talking about with the personal property and everything, it becomes a big issue because you don't figure it out until the walkthrough, you know, and you do a walkthrough because you have to confirm that the property is in the same condition the last time you were there, which was the inspection. And then if the seller was supposed to fix things or anything like that, you've got to confirm that they were fixed, you know, so you have to think about all of that stuff. And it's all about preventing a dispute, because there's nothing that will sour your client's feelings about a transaction than a minor dispute. You know, usually like when there's major stuff, everyone's like, oh, nobody expected that. But when it's something minor, like a thermostat or a doorbell or something, they're like, why didn't you think of that? You know, and you might not be thinking of it because you're like, that's not a big deal, because it's not a big deal, but it becomes a big deal because it's some other barrier to closing, you know?
Second question,
Mhm.
the walkthrough form, like there is no actual walkthrough form that I have seen, except for that re-inspection walkthrough.
Yeah,
But it's very
it's true.
vague, like, I think we should have one form that, you know, for just a regular walkthrough, sign off, you agree, you're happy. Anyone?
Go for it. I'm okay.
I've been on
The
the
more
internet, and they're all
documentation,
so, like,
it,
wow.
I think the more documentation, the better. But like a walkthrough form too, for instance, you guys, if you're negotiating something during the inspection period, you need to be able to modify your walkthrough form so that you can check off the things that you negotiated too. You know, you're going to be checking to see, okay, this item was broken. The seller said they were going to fix it. On walkthrough, did they fix it? You know, I have agents who do walkthroughs and don't check the appliances again. Run the dishwasher again on walkthrough. Make sure there's no leak there. You know, like that's the type of stuff that happens. And then you close, and then your buyer gets in there and they're calling you. And they're like, hey, I just turned on the washer, or the washer's not connected. And then I connected it and now it's leaking everywhere. Well, why didn't you guys look at that at walkthrough? That's what the walkthrough's for, you know? So that's the type of stuff where absolutely, you know, and if you have a form, then it's prompting you to go through all of those things, because then you could check off, you know, and sometimes your buyers aren't there to do the walkthrough and they're relying on you to do it. If that's the case, now you really got to be on top of it, because then they're going to come after you and say you didn't do your job, you know? So yeah, I would definitely, I mean, I would brainstorm like all the different things that you guys look at for walkthrough. Yeah,
So you
I would
guys, in
definitely do
general, you
it.
don't use them.
Well, this is the thing, there's not like a formal like walkthrough form, right? So each
Right.
agency usually has their own way to walk through for their.
Ah.
But, you know.
I would create a template, especially for you, being a transaction coordinator for multiple agents. Like if they don't have one, or if you need to get it, like, hey, you can send it too and say, yeah,
They're so long and so too much, too much.
yeah. Well, you can, and they do, I always go to Google first. Whenever I don't have a form and I'm looking for something that I need to generate for everyone, you know, I'll go to Google first and then I'll modify it to meet my needs, you know? So I've seen walkthrough forms that are really super long. And you don't want one that's really super long. You want one that has like the major things that you need to put in there, you know? But something can still be long, but at least easy, you know? Like I also, like I wouldn't just write appliances work, because what if some of the appliances work and some of them don't? Or like you forget to check the microwave because microwave's not written there,
Yeah,
stuff
but
like
if
that,
don't
you know?
put that on that form, if you don't put,
Yeah.
like the details, then you're passing it off to the
Yeah.
buyers. It's their,
Yeah.
they're being held
Yeah.
accountable.
So, I mean, I think
I'm happy.
I like forms should be easy to fill out, but some of them are going to be long, because especially with this stuff, there is a lot of stuff to go through. And then you need to modify them based on the terms that you've come to an agreement during the contract. Because stuff changes. Not every deal is exactly the same.
So at this point, should we be only accepting this contract?
As a listing agent, I would only take the new contract because it's a little bit more seller friendly.
Yeah, I noticed.
Yeah.
Because the seller actually does have more options. than the other.
Yeah, it's a little bit more seller friendly.
Especially since, if they don't meet that, or don't, if they don't meet the, they do not acknowledge.
Yeah.
The loan commitment.
Right, if they're silent.
If they're silent, the seller actually has the option to like cancel the contract.
Yeah.
So,
Well, they have that under the old contract too, but it's more about whether it reverts to cash transaction or not too.
Okay.
Yeah. And then you're gonna see the old contract and the new contract a lot because some people don't have real software licenses. They just have like an old software that they bought once. You'll see them, but I mean, for the most part, like the software program I use, it updated automatically. I'm pretty sure like Transaction Desk and, you know, some of the other ones, they just automatically updated, you know?
It did update, but I noticed that when I go into like the document section, the old one is still there. You have to
Yeah.
delete it.
Yeah, you can still choose the old one. And it's not like illegal to use the old contract. You could still use the old contract. You know, it's just that now you have to be aware of what rules am I operating under? You know, for instance, under the old contract, texting is formal notice now, but under the new contract, it's not. You know, so if you're going back and forth and using the old contract versus the new contract, you could be confusing yourself. And, you know, you really just shouldn't be texting for formal notice anyway, but the different contracts have different rules. 5 p.m. deadline under time. If you're under the old contract and you have a deadline and it goes to, you know, on a holiday or a weekend, then you only have until 5 p.m. Under the new contract, you have until midnight. So yeah, the new contract, you're not even thinking about that anymore. All the deadlines are midnight. Okay, great. But if you all of a sudden have a contract that's on the old contract, now you need to be thinking, oh my God, if this happens, I only have until 5 p.m. So you do have to be aware of this. That's why I'm kind of like, just use the new contract for everything. Then you don't have to think about that stuff and you just have to focus on the new contract.
Just
you
remember
know,
the closing dates on the second page.
Yeah,
guys.
second page for closing date. It is not a valid contract if there's no closing date on
That's so
there.
crazy.
Yeah. Yeah, it's just dumb.
Thank you.
All right, we're done, guys. Goodbye, everybody at home.
Thank you, CJ.
Thank you. Thank you. Autographs afterwards.